Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. This is our bi-weekly, every other Thursday community conference call in which we discuss your posted questions. Today is June 16th, 2016. Let me, at the very outset, tell you I will not have time for new questions today. So if you were hoping to ask a question that has not been posted, we won't have time for this because we have more than enough issues to discuss already. There were about 20 to 23 questions posted. Usually we cut them off at 18, but this this time around they were just too quick and we couldn't cut them off. So I'm going to be able to only answer the questions that have been posted. If you were hoping to ask a new question, I won't be able to do it this time, but in 2 weeks maybe. Okay, so I have marked some of the questions as frequently asked questions. The first one is traveling on I-551 stamp and maintaining green card. These are two different issues. First of all, when you get your green card approval, you can get a stamp on your passport that says processed for I-551 temporary proof of permanent residence while you are waiting for the green card to arrive. That stamp is as good as a green card. So you can travel on that. That means you've got your green card. It's merely a different kind of proof than the green card itself. So a stamp is as good as a green card. Now, the other part of the question, which is how do I maintain my green card? And what are the parameters of maintaining a green card once you have it? I have addressed this issue several times. I'll do it one more time. Folks, the way it works is a green card is predicated based upon your intention to live in the United States permanently. So technically, if you leave USA even for one day, intending not to return or not knowing when you will return, USCIS could take away your green card. Okay. If you go and you have a certain period in mind, I'll be gone 3 months or 4 months or 5 or 6 months, you definitely have enough to maintain your green card. Okay, so the most important thing is your visit should be short and foreseeable when you leave the United States. This idea of 180 days being safe or 179 days being safe is a little misplaced and a little misleading. I'll explain to you how. Normally what happens is if you have a green card and you leave USA and you come back within 6 months, government does not question you very closely. That does not mean they cannot. In technical words, it is not considered to be a re-entry. But just not to make it any more complicated than it has to, in simple terms, if you come back within 180 days, they won't question you very closely. If you come back more than 180 days later after you have left, but less than 1 year, chances are you will be questioned very closely. Where do you live? Where do you work? And if you, for example, if you have a job in your home country, they can very easily take away your green card. Okay. Typically what happens is if a person has a green card and they show up at the airport, the government will let you in. They have to let you in, but they can lift your green card and eventually schedule you before an immigration judge where you will have a hearing. And in that hearing, your green card will be then coming under question and they can take that away after the hearing. Okay, so your question is, I have to go back to USA within 179 days if I don't have any extension letter. There's no such thing as an extension letter. People get something called a re-entry permit. There's something called a travel letter. That's something different. But typically, a re-entry permit form I-131 merely declares your official intention to the government that you intend to not give up your green card. Folks who have just joined, I will not be taking any new questions, only posted questions. Okay, so therefore, keep this in mind. My advice would be to come back as early as you can. Bear in mind that you must establish permanent residence in the United States. If you cannot do that right away, you should look at filing a re-entry permit. And if you work for a US company or a branch of a US company, look at also something called Form N470. A lot of this information is in our blogs, in our frequently asked questions. You can review those. Okay, anybody has any follow-up questions on this issue I just discussed? Press *5. No new questions, please. I won't have time for new questions this time. *5 if you have a follow-up question. Okay, let's go on to the next frequently asked question. This one is from Siddharth Agarwal. Says, this is about H1 changing jobs before 1st October, etc., etc. This is also a very frequently encountered situation. Unfortunately, very little of what I'm going to say is documented. What I'm saying to you now about the quota exemption and when you can change jobs is based upon our conversations with USCIS at various times. This is not written down, so it is always best to double check this information before you make a decision. Okay, so this is how USCIS looks at it. I'll give you an overview of quota. If you are in the United States, let's say you are an F1 OPT or OPT STEM extension, and your case has been selected in lottery. Let's say you get your approval of the H1 on August 1st, but you know that your H1 only begins on October 1st. Government maintains that if your employer who processed your H1 revokes your I1 your H1 before October 1st, you are subject to the quota again. So the principle there is that before the quota exemption could begin and the new fiscal year could begin, your case was withdrawn. First scenario. Second scenario, if another employer applies for your H1 transfer, and let's say the transfer happens on September 15th, now even if the old employer who did the first case revokes your case, government, this is where things get a little shady. I'm not quite sure how government comes to this conclusion. Government feels that you're not going to be subject to the quota, even though H1 was withdrawn before October 1st, but another case was approved, fully approved before October 1st. That's the way they are looking at it. I am uncertain what the logic there is, but that is their logic. And just to add on to one more thing, if you're outside USA, government's thinking is until you get an H1 visa stamp, you are not exempt from the quota. So even if you get an approval of the H1, unless you go for visa stamping and get the visa stamp done, you are not exempt from the quota. I don't understand the rationale behind it because the statute and the regulations only talk about H1 approval. They don't talk about visa stamping. I have successfully processed 2 or 3 cases last fiscal year where this sort of situation arose, and we did not believe the government's interpretation of the law regarding visa stamping being the gateway to exemption was correct, and we were able to get approval. So double check what I'm telling you, but this is the way it works. So let's look at Siddharth's question. He's on OPT extension. EAD is good till June 2017. H1B was picked by employer A, awaiting approval. Company B wants them to with a better offer. Am I legally allowed to change my employer before October 1st and before H1B visa stamping because you are in the United States? Yes, but double check it. What I just told you covers your situation completely. Any consequences during green card processing? No, no consequences. If employer B files a petition and there's an RFP, what will happen to my H1B with the employer A? Nothing will happen. The way it works is denial of a subsequent petition does not in any way affect an existing petition unless in routine you were already in the H1 process and you changed over before the approval. Then you could have an issue. Here, there is no such issue. So if employer B visa transfer petition is denied, what happened with A? Nothing happens with A. So that's not a problem. If employer B visa transfer petition is approved, can any of the actions of employer A lead to withdrawal cancellation? I just told you that as well. USCIS seems to believe it does not if the transfer is complete. And in any case, after October 1st arrives, it is not a problem at all. But double check with the USCIS, because this is all oral conversations. There's nothing written down on this. Any follow-up questions on this issue? We are not taking any new calls today. We won't have time for that. So anybody who has a follow-up question on this, *5 on your phone, please. Okay. All right. Here's an interesting question. Achilles66 says, how can I find out which company sponsors green card? Well, first of all, EB2 is available to somebody who's got either a master's degree from the United States or who has a 4-year bachelor's degree or 4-year bachelor degree equivalent and 5 years of progressive experience after bachelor's. So you would definitely qualify if your job requires MBA level education, because you have an MBA from the American University in Washington, D.C. So you don't need an MA or MSc. MBA is just as good. Okay. So your second question is very interesting. You say, how do I find a company that sponsors green cards? And the answer is, if you go to the web, well, I was going to do a Google search for you, but there is actually Department of Labor maintains what is called disclosure data. So if you Google ETA, which is Employment and Training Administration, disclosure data, you should have a comma delimited file, Excel spreadsheet, as well as a PDF document. You can download in any format. And it tells you how many companies in the United States have filed for green cards and what kind of green cards, what salaries, what job descriptions, name of the company, address of the company. So you can find from disclosure data which companies are processing green cards for their employees. Okay, that's the easiest thing to do. *5 if you have a question on this. No new questions. We will not be doing new questions today. *5 if you have a follow-up question. Okay. Next frequently asked question. So this is also a common situation where there's a name discrepancy. For Shahab, what happened was he started off with first name unknown, ended up with last name unknown. So the embassy in India has a different name for him, FNU. Green card starts with LNU. All of this can be resolved. There are several ways of doing it. If you are stuck in a situation where you have discrepancy, you've got your green card approved, your passport approved, very easy. What you do is, first of all, you decide what do you want your name to be. Okay. So, and I think it's important to have consistency in the names, because when you travel, you could end up with problems. So we choose the name, whatever name you've decided, let's call it the legal name. What you do is, wherever you are in the United States, call the local court system, ask them, I want to change my name. What do I have to do? So most court systems in the United States, local courts, it will be a state court, not federal court. You'll call the county court and they will send you forms, etc., for the name change. So you publish that information in the newspaper and a court gives you a decree. Usually you don't need a lawyer for these things. So the court orders the name change, and now you have a court decree that gives your legal name. Using that, you can change your green card, your social security number, and even your passport, but that you should check with your home country government if they have a problem with that. But normally, this is the best process to follow. Okay. Now, as far as the green card processing, H-1B processing, all of that we can muddle through. But ultimately, we do want to get this corrected, and correcting your name and making it a legal name is best done through the county court system, wherever you're located. You don't have to be a green card holder. You don't have to be a citizen. I am not aware of Again, depends upon the state law, but at least in Virginia, I do not believe you have to have anything except domicile in the state. Okay. Any follow-up questions on this? Press *5 on your phone, please. Any follow-up questions? No new questions today, I'm sorry. We are going to be very busy with the questions that we have. *5. Okay. Next frequently asked question. I think we're done. No, here's one. Oh, this is very important. So Janus99 says, how can employees save themselves from corporate fraud by employers? So typical situation is if an employer has committed fraud, their company is under indictment, the employer is under indictment, and the cases are being reopened. So there's all kinds of problems that happen. I just want to make sure I have enough time to cover this issue. It's a very large discussion, but I'll try to cover the main points. Before we can decide how you can protect yourself, let's look at what the fallout of these cases is, from most serious to least serious problems. Most serious problem is if you are involved with the fraud as an employee, you gave false documents, or you lied to USCIS or to Department of Labor, you could be criminally prosecuted. So the worst case scenario is if you are a co-conspirator, if you are involved in the conspiracy or the scheme, you are looking at some very serious consequences. You could end up being in criminal court, you could end up being in prison. So worst case scenario is involvement in the fraud or the scheme to misuse the system. That would put you on the same footing as the employer. So you don't want to be a part of that. Typically what happens is, we have seen cases like this, when employers get into trouble, if they're not represented by good counsel who know what they're doing, they start calling their employees, oh, if Department of Labor comes, tell them this. Don't do that. Do not lie to any government agency. Because if you tell the truth and get into trouble, chances are your trouble is much smaller than if you tell a falsehood and get into trouble. Okay. So one thing you can do to protect yourself is do not participate in any of those schemes with the employer. Number two, do not lie to any government agency. Do not become part of any lies. If you know that, for example, your resume is being submitted to the government and it's not your true resume, you should absolutely not allow that to be used. And if they are using it, come back, talk with me here in the community conference. We'll figure out a way to protect you. Okay. So don't become a part of their fraud. Don't submit any documentation you know to be false. There have been cases where employer got into trouble because the employee gave false documents and false information. We have solutions to those issues as well, but that's kind of beyond the topic of what we were discussing. But there are many, many permutation combinations of what can go wrong. So that's the next thing that you should do. Make sure your documents, you're not submitting anything which you know to be false. Okay. Now, what if the employer is indicted? You come to find out that your employer has been arrested or indicted. I definitely think you should immediately call your lawyers, find out whatever you can, and I would certainly be happy to talk with your whole group on this conference. We can discuss and see what needs to be done. But if the employer is indicted, the typical consequences is they go after the H1s and they go after the green cards, even those where the I-140s are approved, and sometimes even those where the I-485 is approved. Typically, what I try to do is I try to speak with the US Attorney's Office and see if we can make some kind of an exemption for the employees, maybe get some concessions from them, which we can then use to protect you from being out of status or being left stranded. It's not always possible, but calling a lawyer as soon as you see signs of trouble is very important because each case is different. So you should do that. These, in a nutshell, are some of the things that you can do to protect yourself. Look, whether the company is fraudulent, non-fraudulent, it is very difficult to say. The laws themselves, immigration laws in the employment context, are so crazy that even the best companies in the United States end up being somewhere or the other technically in default or technically violating the regulations because the regulations are either non-existent or very, very complicated. Okay, so bear this in mind. Nevertheless, you should follow the guidelines that I have given, and hopefully that will protect you amply, or at least as much as possible under the law. Any follow-up questions on this issue, press *5. No new questions. We will not be doing new questions this time, please. We can do new questions the following next to next Thursday, but this Thursday we have enough on our plate. We won't be able to do much. Okay, no new questions. So this was the last frequently asked question. Now let's go back and start taking all the questions that were posted in the order they were posted. A 485 applicant says, I have a pending 485, priority date of October 2009. This is through employment. I got married to a US citizen. There's an I-130. However, the 485 was not refiled, and your lawyers did the right thing. They saved you money because government has indicated that if you have an employment-based 485 and then you get married to a US citizen, they can use that same 485 and attach it to your marriage-based case. So sometimes that should not be disturbed because filing a new 485 could cause delays if government doesn't understand what is going on. Okay. The fact that your application has been now put in the family-based queue as it has been transferred, it looks like it has been taken care of and it has been assigned to a field office. So you wanted to know, if you decide to switch jobs, would I need to file an AC-21? Well, you know, AC-21 is not required to be filed even if you don't have a second green card going. So I don't see any need to do that. I agree with your lawyer. Do I have to switch jobs with the same job description? The answer is no, because now you are going through a marriage-based case. Is there any risk to the 485 application from existing employer? The answer is again no, because one, 485 is your application, and two, it is now appended to your US citizen spouse-based case. Is there a way to confirm whether the application is at the local field office? You can certainly call USCIS customer service. They can give you that much information. You can even do an InfoPass appointment and go into the local USCIS office. Okay, processing timelines and all, they are there on the web. If you go to USCIS website or even on our own website under processing times, we have links to all the national processing times, which are approximations, not mathematically accurate. Any follow-up questions on this that I have discussed? *5, any follow-up questions? Okay, no follow-up questions. Either I am too clear or completely unclear. Well, I'm trying, guys. RAM77, options available to stay if the L1 visa expired. Well, visa, we don't care. I-94 expires April 8th, 2017. There are no options to extend an L1B beyond 5 years other than if you can qualify for an L1A. If you can qualify for an L1A, if the company can offer you a managerial or executive position, they can convert your case to an L1A within the United States, and they can get you an additional 2 years stay in the United States. Okay, even if when you entered you were only eligible for L1B, by giving you a promotion, they can definitely convert you to L1A. This is a known procedure. It's a part of the regulations. That gets you another 2 years. Any follow-up questions on this? *5, please. Okay, we're actually zipping through quite quickly. I might have time for one or two questions. Depends. I can't really guarantee it. We'll see how it goes. Shashi Kiran landed. I have a valid H-1B visa till September 2017. Came to USA Feb 18th, had to return Feb 19th. The next day, wife was met with an accident. Then May 15th came again, returned on May 17th. This doesn't look good. This looks like, well, I'm just telling you the optics of the situation, what it looks like. You may have very good reasons like your health, etc. You see, the most important thing, Shashiji, is this. When you have an H1 and you're traveling to the United States, there must be a genuine job, the job that was applied under the H1 that you got a visa from. It must be available to you. Okay, unless there is a very good reason and a very good explanation, government can start looking at you quite suspiciously. I am just very uncomfortable with the situation. And you are definitely not subject to the quota for 6 years once your H1 is approved, even if you never came to the USA again. That much is quite clear. But if you did come back, I would be very uncomfortable because your situation does not look like it's a, at least the optics, that it's a genuine use of the H1. Star 5 if you have a follow-up question. Star 5. Press star 5 on your phone. J82 had a question about Canadian visitors visa. I have no idea. We practice only on this side of the border. So I only know about US laws. There's somebody with a question about DV lottery also. We don't do DV cases, so I will not be able to answer your question. We decided very early when the DV lottery first started, I just did one or two cases. And then I realized you don't really need a lawyer for this. So we stopped taking those cases. So I'm completely out of touch. Our work is employment-based, business-based, complex immigration cases, immigration-related federal litigation. Those are the sorts of things we do. Family-based cases, normally you don't need a lawyer. Citizenships, you don't need a lawyer. But we do take those cases either when our clients want us to or if there is some complicated factors. Okay, next question is from Kanth need help. I have stayed in USA for 2 years, 6 months on H1B. Left in July 2010. Since it's less than 6 years, can I find another job? Well, if you get your H1 approved by July 2016, you should be exempt from the quota. But I'm not quite sure how that plays out with your something called remainder rule. I'll have to think about it. The remainder rule is this, Kant. Basically, if somebody has exhausted, let's say like you, 2.5 years of H1, then they leave the US and they're outside USA for 1 year, they have two choices. They can either be quota exempt and just claim the remainder of H1 that is left, not the whole 6 years, because after 1 year of stay abroad, you become eligible for 6 years. The second option is you can actually opt for 6 years, but then you'll be subject to the quota. I think after July, you're going to have a problem. But do look into the remainder rule and see if that has any application and helps us. I can't think how it would. I think you've got a problem after July. You'll be subject to quota again. But of course, you also have 6 years of H1 again. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay, folks, a reminder, I may not have time to answer new questions for all those people who have logged in, hoping to ask a new question. I probably won't have time this time around. We can take it. They took too many questions. I like to cut it off at 18. They took 23, so it's a little bit more difficult to deal with them. And Parihar, Nitin says, I'm on OPT expiring July 2016. Employer filed for H1B. It is selected. My case is in premium. Wife is in India. Once H1B is approved, should I apply for F2 and then do an F2 to H4 change of status? You can do that. But if she's coming after October 1st, it will be very easy to just get H4 visa stamping done. Okay. And usually getting H4 visa is easier than getting F2 visa, usually. But that's the general rule. It's not necessarily script written in stone. So it could go either way. But if you wanted to come more quickly, like right away, you should, of course, then you have no choice but to go for F2. Nitin, if you are on the phone, any follow-up questions, press *5. Okay, here we go. Nitinji, I can
Hello,
hear
Rajiv.
you. Hanji, how are you?
Okay. Good. How are you?
Good, go ahead.
Most probably we'll go for H4 then. My question would be related to this one is, uh, uh, we can apply for H1, I mean H4, sorry, right now, right? In August or anytime before October.
There is, I can tell you about the H1, and I'm guessing that the same process and laws will be followed. So let's say you were outside, Nitinji. Your H1 got approved. Because consulates don't like a lot of rush of H1 visas, many consulates make an exemption. They might let you apply for an H1 up to 6 months ahead of the start date. So once you have an approval, you could go and get your H1 visa stamping done. However, you cannot enter the United States until 10 days before October 1st. Okay, so my guess is if the same regulations apply to your wife, they may or may not, she would be able to get her H4 visa now, but she will not be able to enter the US until what, about September 11th? Oh, no, September 21st or 22nd, something like that, 10 days before
Okay.
October 1st. So
Okay.
something to keep in mind. But if you want to be even more secure, I always tell people I'm not a law professor, I'm a lawyer. My job is to minimize risk and find the best solutions. Practical solution is just enter on October 1st or after. Okay.
Okay.
Anything else?
And that would be all. Thank you so much.
Oh, you're very welcome. Good luck, sir. Okay. Again, people who are just calling in, I may not have time for new questions. We have more than enough questions. If we are able to zip through them and I still have a few minutes remaining, I can try, but don't depend upon it this time. Okay. GC aspirant 21. Hi Rajiv, I need your help in checking if I can get my H1B transfer from this employer to another with delayed pay stubs. So what's happening in this case is that the company is small and they're going through one of the payroll services and there's a little delay in the payment. So the whole pay cycle is a little delayed. Look, I don't think that puts you out of status. You've been working. You will eventually get paid. And the employer is on a cycle that is predictable and sure. Even though I think the employer might be in violation of the H1 regulations, I don't think USCIS can hold you responsible for that. Okay. So I think you'll be okay with old pay stubs. And if asked to provide an explanation, I wouldn't worry about it. I think you can do a transfer based upon this. If you are here, press *5 if you have a follow-up question. *5 if you have a follow-up question. So yeah, in my opinion, you should be able to transfer. You're here. Okay, let's go ahead, please. I can hear you.
Hi, Rajiv. Thank you so much for answering that because I've talked to a few of my friends, and what they've told is that once there is a chance of getting a RFE. So I mean, I just wanted to check, make sure that that doesn't happen, or yeah. So that.
See, RFE is never a deterrent. RFE is
Okay.
something we expect in almost 70, 80, 90% cases. That doesn't bother us. The question is not RFE. The question is the case most likely approvable? And the answer is yes, it is most likely approvable. I wouldn't worry about it. This delay cannot be attributed to anything that you are doing wrong. So I think you're going to be okay.
Okay. Okay. Yeah. Like I said, also in my bank statement, the salary credit, so I can show that as a proof,
Yeah.
but not the actual pay stubs from ADP.
Yeah, that's fine. And how long have you
Okay.
worked for this company?
It's been since March, so this March, so 3 months.
So you already have your W-2 for the year, don't you?
No, I don't have it for this year because I just started working from this March.
Oh, March
so
20. I'm
March,
sorry.
April,
I'm sorry.
and May.
My mistake. Okay. No, I think you'll be fine even if you don't have a W-2 because your transactions, bank transactions probably show the inflow of the salary. Um,
Yeah.
you actually, ADP should be able to give you a copy of your pay stubs. If you ask the employer, or I don't know if you, I don't think ADP will talk with you directly, but if you ask the employer, they could probably give you the pay stubs. But even if they don't,
Mm-hmm.
there is a very good chance that
Mm-hmm.
USCIS will accept your situation because it's a little unusual. You should be all right.
Okay.
All
Yeah.
right.
Thank you so much, Rajiv. Like you said, I have an ADP login, but even when I log into my ADP, it just shows the pay stubs which I've got. It doesn't show the rest, the previous one. So yeah, this answer is kind of good.
Yeah,
And
take
like you
the
said, I should be fine.
take
Yeah.
the screenshots of ADP access, whatever you have. Take the screenshots.
Mm-hmm.
Okay.
Okay.
Good
Yeah.
luck.
Thank you so much.
Oh, you're welcome. Bye bye. I still see people logging in, guys. I may not be able to do new questions this time. We have enough. So, but next time we will. This is a DV lottery question. As I had indicated, we don't do DV cases. So I pass on this one. Kintal, my current H-1B expired in May 2016. Extension in progress from Feb 2016. Still not approved. I-140 approved. Project is closing out. Can I move to any new employer now? It's a very interesting situation. Actually, I should have marked it as a frequently asked question. But nevertheless, so we have a situation where the original H1 has expired, but there's a timely filed H1 extension that is now pending, right? So you're not out of status, you're not even unlawfully present, but that case will not be approved because the project is over. So what happens if you transfer? It's a very interesting situation. And actually, I'm dealing with it right now. Today, this morning, I had a consultation with a client. The only difference is, in their case, it's the same employer. The first project ended and the extension request was still pending. So we moved them over to a new project and we are filing a new H1. In these cases, if you can establish that the pending case was approvable when filed, which means you could produce an end client letter or documentation to show there was a project, chances are your transfer will be approved. Worst case scenario, you'll have to go outside and get a visa stamping done for the new employer. It's not the end of the world. Okay, so if you are here on the phone, press *5 if you have any follow-up questions on this. *5. Okay. Vittorio is an Italian citizen. He wants to open, and he's here on H4, wants to open a company and apply for E2 visa. See, Vittorio, it kind of becomes a little gray because on H4 you're not allowed to begin work. You can set up a company, but make sure you don't begin work until you get your E2. Okay. So your question is, I've been asked by an American citizen if he could be a part of the company. Can a treaty country citizen partner with an American citizen? Absolutely. Absolutely. No problem. But there are other things you have to worry about. As you know about E2 visas, you probably have studied this. E2 visas require certain things. Your investment should be substantial in relation to the cost of the acquisition of the project. This itself is a big problem. Sometimes the government doesn't look at the cost of acquisition. They start looking at the cost of the asset. Let me explain to you what I mean. So let's say I buy a hotel. The cost of the hotel is $12 million, but I can buy the hotel by putting 20% down. So really, my investment should be measured against the 20%. It shouldn't be measured against the cost of the hotel. The cost of the acquisition is what is important. So your investment must be substantial. It doesn't matter, your other partner can be putting in whatever money they are, but you should definitely have substantial investment. The investment must not be illusory, and it must not be just buying you a job. It should give you some dividend or some extra amount over the bare subsistence amount. So it shouldn't be like getting you $25,000 a year as a return, at least, more than what a basic livable amount is. So when all those things are met with, you can definitely partner with a US citizen. And also remember, if for some reason it doesn't work out, I always like when I go for E2, all my contracts are usually something that we can back out of if the case is not approved. And even the money, usually we put it in escrow. We don't just put it in the property or the investment itself or the business itself until the case is approved. So you may want to do something like that with your partnership also, that this partnership will be subject to approval of the E2 visa. You can kind of do that. Next is, my wife is currently under H1B. Her visa is valid till September. So she's on H1B. There's waiting for a response to RFP for change of employers. In the scenario that she travels with you to obtain the E2 visa to Italy, if she gets a refusal, could we go back to the US to organize our things? Doesn't Italy have visa waiver kind of you can enter without on ESTA? I think it can. So otherwise, you can always attempt a tourist visa, explaining to the consulate why you need to get back in. Usually that's not a problem. And also remember, an H1B refusal is not cast in stone. Another employer can file an H1 and she can get an H1 visa stamp and come back, or maybe even use the same visa and come back. If you're on the phone, Vittorio, *5. Press *5 if you have a follow-up question. Okay. Ask 341 says, I lost my job Feb 15th. Okay. Working on H1B, I filed my change of status on Feb 16th. That's too late, actually. I don't know if you were getting paid. One second. USA has asked for the following things: travel arrangement for departure. Okay, that's normal. Copies of pay records for the period all the way to Feb 22nd. But you filed, your package was delivered on Feb 20th. That's the date that counts. Feb 20th is the date when you filed the case. Okay. Once again, let me remind you folks, people who are just logging in, I will not have time for new questions today. Sorry about that. We are kind of we got too many questions. So no new questions today, sorry. So since my job ended on February 15th, I do not have any documents. Oh, I see. Yeah, I think your change of status is going to be denied. And I think you are in unlawful presence if we assume that your employer revoked your case effective Feb 15th. So under no event, we should assume the worst case scenario and get you out of here no later than 180 days from Feb 15th. Okay. You should still be able to get another H1 and come back. That's not a problem. But I don't want you to get stuck with a 3-year bar or a 10-year bar, not knowing what has happened. So assume that you were unlawfully present out of status from Feb 15th and leave before 180 days if the B visa or B status is not resolved. Okay. So *5 if you are here, *5 if you are here and you have follow-up questions. Let's get to you. Here you are. Okay, I can hear you. Go ahead, please.
Hi, Rajiv. Can you hear me clearly?
Yes, California, I can hear you.
Yes. So I have an additional question. Thanks for the clarification.
Mm-hmm.
Uh, I did get a job offer recently, and the
Mm-hmm.
company will start the H-1B filing process soon enough.
Mm-hmm.
Um, so, uh, what should I do? Given that the B1, the B2 petition is very likely to be denied, should I just withdraw the petition and hopefully the H1B gets approved because it's a pretty large company that has offered me a job?
This is what I would do. I don't know what they would do, but if I were representing you, what I would do is, first thing, I would respond to the RFE telling the government exactly your situation, that I was out of work on Feb 15th without any notice. I'm assuming there was no notice, right?
Uh, sorry, I could not hear the last thing you said.
Did you have notice before Feb 15th that you were going to get laid off on Feb 15th?
No, I did not have any
Yeah,
notice.
so basically, I would tell the government this is what happened in response to the RFE. And I would also tell them I have another job offer from this company and they're starting another H1 for me. I respectfully request that please approve my B visa so I can transfer back to H1. That's one thing I would do. Second thing I would do is when I file the H1, I would explain to the government that there's a gap and this is what happened in the gap. And here's a copy of my RFE response to the B1. So I would kind of tie it all up, but I would still keep an eye on 180 days from Feb 15th, and I would file the H1 premium processing. That would wrap it up. I have a pretty good chance of success.
So I should separately respond to the RFC requesting that they approve the B1 because I have a job offer, etc.
Absolutely.
And the company should also include the information about the RFC and the petition when they file the H1B.
That's what I do because I like to wrap it all up in a neat package to show the government that I am out of status for no fault of my own. Unexpected layoff. The current H1 regulations provide no grace period. I am out of status right away. I did my best. I got the B visa application over, I-539 over as quickly as I could. So I think that is your best shot. Worst case scenario, you go out, get a visa stamping and come back.
Oh, okay. Okay. When I filed the petition, the visitor petition, um, I did not know what is the best reason to make a case for me to stay here. So I said that I have left my job, being embarrassed of having lost my job, and I have family in the US, so I want to stay for some time. I don't know how
Well,
that went.
that is a singularly bad idea. Okay. I always tell people if you ever have an issue with the government, pick up any. I'm assuming you are from India. Pick up any currency note on which the official seal of the government of India is there. The four lions, three of them you can see. At the bottom of it in Sanskrit it says Satyameva Jayate. Truth always wins. Remember that. Always tell the truth. Okay. There is really no need because this is such a genuine situation. Now, how you're going to deal with it, it's a very long discussion. I can't do it here. I would suggest you talk with your lawyers, discuss it with them. It shouldn't be the end of the world. Worst case scenario, they might say, okay, just go out, come back with a new H1 visa. Don't worry about it. But I just think that it is not something I can address in 5 minutes. Okay?
Okay. All right. Thank you.
You'll be all right. Don't worry. Good luck.
Thank you.
You're welcome. Okay, guys. Just remember that whenever you have any difficult situation, always tell the truth. It's not the problem is, you see, let's say you tell the truth and you get into trouble. There may be 9 out of 10 some chances that we can get you out of that trouble. But if you tell a falsehood or a misrepresentation, any attempt to procure or procuring a visa or immigration benefit through misrepresentation is a permanent bar from entering the US. Getting a waiver from that is very difficult. Okay, so be careful. It's also a felony, by the way. Okay, so Oh yeah, this is Ashutosh. You also sent me an email. If you guys ever send me an email in an emergency, please make sure you put your phone numbers there because then I can call you. There's no way I can write an answer to how you can get your visa expedited. These local procedures differ from places to places, and I think that is what my office told you. But anybody who corresponds with me and there's an emergency, please put your phone number so I can call you. Okay. So Ashutosh, if you are here, press *5 because the basic idea is that you have to check with the consulate. If you are here, press *5. Okay. Let's go back to Janus 99. I'm going back to India. H1 is in the second term. I-140 is approved. If I leave my present company in India, they'll revoke my green card in H1B. My new company will be able to transfer my H1B after my present company revoke my green card. Well, that's a difficult question to answer. There are too many variables. There is a variable based upon what the policy is today. There is a variable based upon what the policy might be in a month, 2 months, 3 months time, because there are some regulations pending. Right now, the policy is you keep your priority date if your I-140 is approved. Even if your employer revokes your I-140, you keep your priority date. You have to start the green card all over again. Okay, but this is policy. I don't like policy because policy can be changed. However, there are regulations pending, and if they are approved, what will happen is this. This is on my blog. If you go to my blog, you'll see it. Folks, people who are just logging in now, I will not be able to answer any new questions. We don't have time for that today, sorry. We can do it next Thursday. Okay, so the new regulations say if, and this is regulations now, not policy, if your I-140 is approved, you keep your priority date even if the I-140 is revoked. Right now it is just policy, then there'll be regulations. And the second very important thing the regulation says this. If your I-140 is approved and stays approved for 180 days, not only do you carry your priority date, you also carry with you the right to keep getting H1 extensions on a 3-yearly basis for any employer, even if the old employer revokes the I-140. So 180-day approval period, if it stays approved for 180 days, you are good as gold. Okay. So your question was, can my H1 be transferred if my green card, etc., is revoked? And that depends upon, right now the policy is you can't get, the policy is you keep your priority date, and the law is you can't get H1 extension beyond 6 years. If you have time left on your 6 years, which you do, any company can process you either under the remainder option, which means no quota problem for you, and the second way is to put you under the new quota and get you 6 years. So remainder option, just remember that phrase, that would help you. If I don't leave my present company in India, they will not revoke. After 2-3 years, if my company will try to extend my H1B, can they do it? And the answer is yes, because they have an I-140 approval for you. Okay, so I just explained to you how the priority date can be maintained under the current policy. Even if you leave and they revoke, you will keep your priority date, but that is a policy. So I think you can wait until the regulations come out. If the regulations come out and they are in the same format in which they were proposed, then what I just told you would be the law. You will be happy, happy, joy, joy. There's no problem. Okay. *5 if you are here and you have a follow-up question. *5, please. Okay. This is also Janus 99. Oh, same question twice, I guess. Okay. Swap Shubh says, I'm currently working as a customer technical support engineer, post-sales support engineer, for the same company for 3 to 5 years. and my I-140 is approved, I want to become a sales engineer, pre-sales engineer. Yeah, I understand that. Okay. H-1B amendment will be done. The title on the label is Network and Computer Systems Administrator. Look, I cannot tell you if this will work for your green card. I cannot tell you because I have to look at the language, exact language used. Job title by itself doesn't tell me anything. I have to look at the job description of the job that you are going to and the job for which you were labor certified. Remember also, let's say you were certified for network and computer systems admin, okay? And you're working as an engineer pre or post sales, you got your H-1B amended. What if it is your intention to come back to the administrator position once the green card is approved? In the meantime, you can have any position. So that's another approach. So it all depends upon which way your employer is thinking about your job. So one thing I would look at is, are these two jobs about the same? And the second thing, if not the same, do you intend to come back to that job? Star 5 if you have a follow-up question. Star 5. Okay. Rockford says, I lost my job about 4 months back. I was working on H-1B, filed a B2 petition pending. My fiance is a US citizen. We intend to get married. I know that 130/45 can be filed. Out of status for 4 months doesn't bother you. Okay. Just make sure you're not 180 days unlawfully present. Let's assume that's the same thing as the out of status. Because if you're unlawfully present for 180 days or more, then you still get your green card through your US citizen spouse, but don't leave USA until you get the green card approval. That's the only thing. So even if you were unlawfully present for 10 years, if you did not leave USA and you entered USA legally, which you did, and you get married to a US citizen, you get your green card, no problem. Just don't travel outside. Star 5 if you are here, Rockford, star 5. Okay, folks, I have only 4 minutes remaining. I can answer, oh, I guess not. I cannot answer a new question. Okay, let's just go to California. Go ahead, please. California.
You mentioned that if the green card process is started, I should just wait till the process gets completed, which means I get the green card before I travel out of the US.
Let me walk you through the process. Okay, there are two possibilities. I'm going to assume that you lost your job 4 months back and they revoked your case. You are now unlawfully present. I'm assuming that. Okay. Now, one thing I'm not clear about was I was taking the worst case scenario. You said you have a B2 pending. Was your B2 received by USCIS before your job went away?
My B2 was filed after the job loss.
Okay, so I'm assuming that you've been accruing unlawful presence for 4 months. Now, there are two possibilities. Sorry? Okay, there are two possibilities. Either you are filing your I-130/45 before 180 days or after 180 days. Okay, so if you are filing your I-130/45 before 180 days from the date you left your job, you have no problem, you can travel. Once you get your advance parole, you can travel. But if you file your I-130/45 after 180 days, then wait in the United States until your green card is approved. That's what I'm saying.
Okay, all right. So that's the critical difference. Okay.
Right, right. Okay.
I don't know the reason for that, but I guess you probably.
Yes, I do.
I'll just take.
Yeah, I know the reason for that, and that's what I'm telling you. Don't do it. It's unlawful presence of 180 days. If you leave USA, attaches to you. If you remain in the USA, it does not attach to you. It's a little quirk in the law. Okay. Okay?
Oh, okay, okay. But if the I-485 is filed before the 180 days of unlawful presence,
Then no problem.
uh,
Then no problem.
then no problem. I can travel once the advance parole comes.
Absolutely no problem.
Okay,
All right?
okay. Thank you, sir.
You're welcome. Good luck to you. All right, folks. Good talk. I will talk again with you folks. It's almost 1:30, 1 minute less. Don't have enough time to do new questions. Sorry about that. But I usually tell the team to close the questions down after 18. They couldn't do it this time. So anyhow, we'll talk again in 2 weeks. I'll have the recording up in by tomorrow or maximum over the weekend. I thank you for the time that you spend with me. I always enjoy it. See you again soon in 2 weeks. Bye bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.